great shopping.
Long time no see.
Yeah, how much you want to get this time?
I'll save as usual.
Okay. You take it to the loading job. Okay.
Always call this time.
Don't worry. You see, we are all guys so many times. Please trust me. Do you not believe me?
Yeah, of course I trust you, but this time the customer is too demanding, so you know.
Don't worry. This point is very perfect. And how is your sales?
It's very good. The value is high, and every day for our customers. I'm so happy about that.
Okay. So you will be paid the same.
Yeah, pay as usual. We will pay you after we deal with the receipt.
Okay.
Thank you, bro. OK，今天吃喽。还没吃，要抓紧。Boss, the rest of goods are in the truck.
Okay.
Yes, boss, the price already counted.
Okay. So I'm going to leave today.
To the rush, go to the office to drink the tea.
Sorry, today I'm so busy, so.
Okay. Bye. See you next time. Yeah,
See you. Bye.
Bye. Wait, hello? So what's going on with you later? So what's wrong with your company? So why haven't you paid yet?
Yeah, sorry, I forgot. I'm so busy these days. We have cooperated for a long time, so trust me, I will pay you later. Maybe it's the day after tomorrow.
Oh, okay. You go hard. Bye. Yeah.
2 days
The boss of the Hongcheng seafood decided to call me today. So do you receive the money?
Boss, I'm going to talk to you about this. I've been checking the company accounts since this morning, and he hasn't paid us. Boss, will they don't pay us?
Yeah, don't be ridiculous. We have been working together so many times. So he shouldn't want to do that. I will call you again to check. So you can go out.
Alright.
Hello.
Hey, hello. Did you say that you paid today? My secretary never got it. We need the money to pay off.
There's some problem happened to my business. Maybe I will pay you later. I will consult with your secret later. Alright?
4 to 6 days later.
Boss, they still haven't paid us today.
What happened? Okay. Later I will call him again. So what's wrong with you? I tell you to pay us, and you keep stealing. What do you want? I've been waiting for you to pay. My employee is waiting for me give their salary. You will pay me now.
Hello. I told you I need to sell my points first, then I can give you money. What's wrong with you? Why all you call me?
It's been a long time and you have to pay. You have to pay me today. Okay. No. I have already sold you the points, so you have to pay me. What? What? 好了好了。
2,000 years later. Four to 6 days later.
Boss, Hongchen safe send someone to bad news.
Okay, let me come in.
Hello, my boss let me buy the points as euro.
I call your boss. She's not picking up. No, she only made more than the 700 ringgit unpaid. And now she let you to buy the goods. You go back and tell your boss and not to take a single boss of the points from my company until she pay up. Also, divide your boss and wait to the counter sentence. Okay, go out.
Alright, bye bye.
All right. Please be seated and come to order. And this time, please silence all cell phones ring from Tokyo. Thank you. Plaintiff QQ Traditional Defendants Hongchen Seafood both are placed. The court is now ready to begin.
I'm Liu. As you heard, I'm judge here, and I will tell you it's an order to be here. Now the court hearing.
Now the court is in session. Today, the High Court of Malaya at Taiping in the state of Perak is to hear the QQ trading case against the Hongchen Seafood Supplies in an open court in accordance with the law.
Galley discovery is now underway, and the plaintiff invites to state the face of the case and the reasons and the growth of it.
Your Honor, I am here to settle the facts as an agent for the plaintiff. We have had a multi-year relationship with the defendant. As of April 2018, we have consistently maintained a good supply and demand relationship. We have stopped supplying prawns to Hongchen Seafood as of April 2018 because Hongchen Seafood has not paid the amount due to us since November 2017. We have repeatedly requested repayment of the total amount of 1,173,297.80 from Hongchen Seafood until August 8, 2018. Defendant paid us 4 post-dated checks and we resumed supply to Hongchen Seafood with October 2018. Subsequently, we discovered that the check could not be properly drawn, so we made an initial reasonable guess that the other party was not in a financial position to pay the balance in order to prove this guess. Our lawyer on 11 March 2019, Choo claimed 1,223,287.80. However, the defendant has not paid the balance on time, and we have reason to believe that the defendant is indeed financially unable to do so. We therefore ask the court to compel the defendant to repay the balance.
Now give the floor to counsel for the accused.
Your Honor, we object to opposing counsel's point of view. We have not had any problems with insufficient funds, and the company has over $1 million in its account. Therefore, the post-dated checks paid by us to plaintiff were not invalid and unpayable. The reason the plaintiff was unable to withdraw the money properly was because of quantity problems with the bronze sold to us by the other party. So we asked the bank to suspend payment, and we had a mutual agreement that the other party could not use the check without informing us. We have been responsive and have paid 15,000 ringgit to the other party. The plaintiff accepted the payment but did not respond to us, and in the event of quantity problems with the bronze, the other party demanded that we pay the balance as soon as possible and charged 1.5% of interest. We find the plaintiff's claim to be unreasonable. We therefore require the plaintiff to resolve the quantity issue and dismiss the appeal. Thank you.
What's wrong with our parents? You are the ones who personally pick up the goods in the first place and didn't check with the quality issues. And we also working together for so many years. So why you bring up the quality issues now? And you say you have a positive attitude. But I also ask you many times let you to the repay, but you have not completed your repayment on time.
So we have worked together, right, for a long time. So I believe you and you believe me. And for this time, I ask you the quality of the points at first, and you tell me everything is okay. But now what happened? And you see in the repayment process, our attitude is always positive and responsive. And what's your attitude? It's always waving, okay?
You say you have a positive attitude. You owe me the 1 million ringgit, but you just paid me for the 15,000. What can we do use the 15,000? You couldn't even make it on the first class on a plan.
So you see 5,000 ringgit, right? We made an agreement. If you want to take money, you meet the requirement from me. But now you didn't get my requirement and go to bank, want to take back the money. What happened to you? You don't have money and we paid you 5,000 ringgit. So are you blaming now?
Keep quiet.
Your Honor, according to ACT 1950, first section of 56, when a party to a contract promises to do a certain thing at or before a specific time, or certain things at or before specific times, and fails to do so any such thing at or before the specific time, the contract, or so much of it has not been performed, becomes voidable at the option of the promisee. If the intention of the parties was that time should be of the essence of the contract, time was the essence, and both parties should perform their corresponding obligations in accordance with it. We gave the defendants 30 days to pay, and they failed to do so on time, and our request was entirely reasonable.
Can the defendant's attorney present evidence as to the quality of the plaintiff's bronze?
No, we can't.
Perfect.
Both parties have presented their cases and argued over them, which have all been kept in records. This is the end of court argument.
Here it is a claim of the plaintiff against the defendant. The problem began when payments for price were stopped on the basis of low quality price sold by the plaintiff. When payments were not made, the plaintiff assumed that the defendant had a financial problem, and the defendant began shifting the blame to the plaintiff by stating that it had supplied low quality products. There was an initial payment of 50,000 ringgit.
to settle the date, and it had also written to the plaintiff asking for time and avenue for discussion on the affair. The plaintiff refused, closing the door of negotiations and reception of the business. I cannot make a gallant attempt to come to what the plaintiff felt was the correct decision by allowing the summary judgment. There are disputed touches on material facts with gratuity of the price supplied by the plaintiff, non-payment by the defendant, which in fact forms the crux of the cause of action by the plaintiff against the defendant. One of the other issues is which party breached first. A material breach by a party will justify factory issue in accordance with facts and circumstances of the case. The terms of the argument between the parties was material facts. The intent of the parties are questions of fact for this court to decide at the end of a trial, and not based on the affidavits. That would also be the considerations on the issue of interest payable for later payment. On the issues of merchantability, it is a fact within the special knowledge of the defendant. Hence, they bear the burden of proof to prove that the funds supplied were not be the merchantable quality pursuant to Section 106 of the Evidence Act 1950. The plaintiff, on the receipt of the defendant's affidavit, has served an affidavit in reply. On the other hand, the defendant has indeed successfully shown that there is an issue or question in dispute which ought to be tried present to Order 14 Rules 31 ROC 2012. This court, which have in regard to the evidence as a whole, that the defendant's defense is credible. Summary judgment cannot be granted to the plaintiff, as there is a reasonable probability that the defendant has a real or bona fide defense in relation to the identified issues. The application for summary judgment pursuant to Order 14 ROC 2012 is thus dismissed with cause in the cause. This is the end of today's proceeding. Now we are adjourned.
Hi boss, I think I have something wrong with the points. It's soft and blue. I think not fresh.
Well, we finally have the proof to prove that something happened to last verdict. I'm not satisfied at all. Now we have something to prove that. So let them write letter now.
Boss, Hongchen Seafood said the brown were of questionable quality and sent this letter demanding compensation. So what do we do?
Never mind.
All right. Please be seated and come to order. And this time, please silence all cell phones ring from talking. Thank you. Plaintiff Hongchen said food. Defendants QQ Trading. Both are in place. The court is now ready to begin.
Now the court hearing.
Now the court is in session. Today, the High Court of Malaya at Taiping in the state of Perak is to hear the QQ Trading case against the Hongchen Seafood Supplies in an open court in accordance with the law. In the last QQ Trading and Hongchen Seafood verdict, because Hongchen Seafood had issues of fact and could not provide strong evidence that QQ Trading's prawns had quality problems, we ordered defendant Hongchen Seafood to pay damages to plaintiff QQ Trading as a matter of law. Hongchen Seafood has now presented strong evidence that the prawns were of questionable quality. Therefore, Hongchen Seafood moved for a redetermination of the previous verdict and is now proceeding to a second trial.
Your Honor, we initially found problems with the quantity of the prawns in March 2019, but the opening was not adopted by the court in the first trial. Subsequently, we found factual evidence in May 2019 that the prawns were indeed of questionable quality. The quality of the plaintiff's prawns did not comply with the certificate of analysis and Malaysian and international seafood standards. As a result, we were unable to export properly. In addition, we had to bear the cost of storing the goods for more than 70 months, which resulted in substantial sales losses. Therefore, we would like the court to revise the first instance decision to revoke the decision to pay substantial damages to the other party. The other party is required to take back prawns that have quality problems and pay some compensation. Thank you.
Your Honor, plaintiff did not specify that the merchandise was for export when it purchased the prawns. Our quality was in line with the quality of prawns was subject to certificate of analysis plus Malaysian and international seafood criteria. Moreover, the plaintiff has stored the prawns for 17 months before coming to us with the issue of the quality of prawns, which may not be with us but may have been due to the transportation and storage problems. The fact that we only supply prawns has nothing to do with your use of the prawns for export sales or other purpose. You are to pay the balance within 30 days after we complete the handover, which has nothing to do with the quality.
Do you know what's meant by seafood? Your prawns, not seafood, is agricultural food. Do you know that? Your prawns live in the ground, not the sea, and you sell your prawns as a seafood. What's your responsibility about this? What's wrong with you?
It's not my business. Who don't care? Who care? The prawns was raised on the pond, and the pond by the sea with the sea water. So why not the seafood? Just the seafood. Can you show that the quality issues not in the transportation and storage? You cannot.
Keep silent.
Your Honor, the defendant's statement is rebutted here. Seafood is any form of sea life regarded as food by humans. Prominently including fish and shellfish, it must live in the sea. Monoculture is not the same as ocean farming. Defendant's so-called seafood cannot be called seafood, and there is a question of international misinterpretation of the facts by the other side. Thank you.
Your Honor, we do not respond to quality problems. The process takes too long. You should communicate with us if you find problems, and we will inspect the goods properly. If there is a quality problem, we will pay in accordance with the contract. We are unable to respond to this in our current condition. However, there was a factual issue of payment arrears on your part, which we resolved promptly and in accordance with the law. We had sufficient evidence. The judgment against you for the payment of the balance to us was entirely reasonable and lawful. Thank you.
A counterclaim is a cause action by the defendant against the plaintiff. It's aimed to turn the table on the plaintiff by bringing up issues in the case, like the present, which requires consideration by the court. The contract between plaintiff and the defendant and the aftermath contract between the defendant and their ex-boss has to be viewed distinctly. Defines compensation sense. The quantity of funds supplied to the defendant is not little, but for a value of more than 1 million ringgit. The defendant has a greater stake in the contract of sale of funds with the plaintiff and it has to fulfill its part of the promise with its exporters. As the plaintiff has supplied low-quality prawns not befitting the specifications set by the defendant, it has lost business with exporters. Hence, the counterclaim against the plaintiff. The counterclaim is in fact connected with the plaintiff's claim, with the trust being that the prawns were sold and delivered for a monetary value to the defendant, which has turned out not to be of merchantable quality. Since the plaintiff states in its statement of claim that it had no knowledge of the business dealing of the defendant with their exporters, it is a fact to be proved by the defendant via oral testimony of the witnesses that the plaintiff, based on the business relationship with them, has knowledge of it. It is entitled to a summary judgment against the defendant, and that the counterclaim by the defendant ought to be struck out when it had put the defendant to strike proof of its argument in its defense and counterclaim. In sum total, the strike-out application by the plaintiff is misconceived as it lacks basis in terms of the principles applicable to be an Order 18 Rules 19 application under ROC 2012. The mere fact that a case is weak and not likely to succeed is not a valid ground for striking out a claim pursuant to ground of Order 18 Rules 19. As a counterclaim by the defendant claim by the defendant disclosed a reasonable defense on the face of pleading. Further, this course process is not used by the defendant for an unlawful object, but for the actual purpose intended to achieve justice. The matter goes for an open court trial wherein all the issues raised and the dispute of facts demonstrated by the plaintiff and the defendant by ventilated via testimony of witnesses. This is the end of today's court proceedings. We are adjourned.